Good morning. I go by Mike. Every time I get to speak to a group of leaders in law enforcement, I consider it an honor and a privilege. I know your job is to serve and protect your communities. I've made it my job to serve and protect you and your leadership team, your sworn and non-sworn employees through this program. Protect them from what? From the negative consequences that occur when your department gets drug into a lawsuit, which basically is the legal wheel of misfortune. When the needle comes to rest, it's not on anything that's positive in nature. It used to be if any employer lost a lawsuit, the employer wrote the check and life moved on. Well, we can all think of that as the good old days, because now there are plenty of federal and state statutes that have established individual liability from first level leader up to the top. These statutes don't cover everything. That's where judges take over. After a judge has ordered an employer to write a big check, turns to the first level leader, everyone up the chain, and says, for your role in this fiasco, each of you can write a check to the terminated employee for this amount, and by court order, you can't reimburse the leader. There's even a third area of liability. More and more employers have figured out this strategy, tactic actually works. You take your own city employee handbook into court, your own general orders manual, point out the relevant sections, and say, because this leader didn't follow our policy, because this leader operated outside the scope of his or her authority, we're not liable. It's all on the leader. So I put this program together to protect police departments and everyone on the leadership team. From what? A couple of stories will help back it up. If you've ever wondered, why is it employment-related cases take so long to get to closure? Is because the longer it takes, the better it works for the financial interest, not of the employee, but for the attorney that filed the case. I've seen cases where an award to an employee was $27,000, and the award in attorney's fees was $696,000, 25 times as much as what the employee got. Terminated employee goes to a plaintiff attorney and tells them this story. They gave us free logoed shirts and told us so that we would all look nice, we're all going to tuck our shirts in. I told them, thanks for the free shirt, but I'm not tucking it in. I was told as a condition of my continued employment, you'll tuck it in, and I didn't. I got fired. Free speech applies in this country, doesn't it? Sure does. Let's file a lawsuit. $10,000 in legal fees later, the employee finds out there's no constitutional right not to tuck your shirt in. The attorney lied to him? No. Just didn't tell him that the question and the answer was irrelevant. And where did the $10,000 come from? That's about what an employee will find that he's paid out before he realizes the case is going nowhere. Think the attorney knew that was going to happen? We need to protect our sworn and non-sworn employees from being taken advantage of by legal experts. And for you to be successful at that, you don't need to be a legal expert yourself. But plaintiff attorneys isn't the only folks we need to protect our employees from. We need to protect them from themselves. If you let them walk out of your department with a perception of entitlement, a lack of knowledge, or an illusion of immunity, that's on us as leaders. I have certain objectives I want to share with you today about how to coach your leadership team, how to keep everybody out of court. Now, why would I want to keep you out of court? It used to be my job to win lawsuits. I worked for Frito-Lay, and I put a legal team together, some in-house counsel and some outside counsel. They didn't like me calling them out-house counsel, so I had to stop doing that. And our job was to win lawsuits, which we did. Every single lawsuit filed against Frito-Lay in state and federal court for 5 years. How is it we were able to win them all? Because we had a totally effective compliance-based training program, which would guarantee any organization you're going to win all your lawsuits. And I figured out that there's a problem with compliance-based training programs. They teach leaders what not to do. If you have effective leadership, you minimize, if not eliminate, all the lawsuits. I'm so committed to showing leaders how to avoid lawsuits that I abandoned the practice of law. I don't even consider myself an attorney anymore. I'm a recovering attorney. I have no clients and I don't want any. Based in Texas, I'm singing a different tune now. All right. What are my objectives? There's three. Stop employee relations issues from turning into legal headaches. Make sure your sworn and non-sworn employees like not just where they work, but who they work for. Employees don't quit their organization, they quit their leader. And then the last, I don't want your department or you or anyone on your command staff ever writing a check. How are we going to achieve these objectives? It's by putting these strategies into play. Stopping employee relations issues from turning into legal headaches. Part of the answer to that is doing it right in management, in leadership. But there's another important part, being perceived as right. And I'm going to show you how to take the laws that have been historically used to attack leaders' decisions. I'm going to show you how to use them to your advantage. But we're going to take a principle-centered approach built around honesty, integrity, common sense, human dignity. Being pro-department, pro-command staff requires we all be pro-employees. There aren't any enemies in a police department. Why does it work as well as it does? Because it's a team effort. There aren't any enemies on the team. This program, this material, has tactics. Behind these tactics are my beliefs that every one of you wants to use his and her leadership abilities with professionalism, integrity, and fairness. The vast majority of your employees want to do their jobs just like you want. But if you lead people long enough, there are plenty of opportunities for you to run into potential liability situations. In these situations, leaders who know what to do, how to do it, have a tremendous advantage over those who don't in avoiding self-inflicted lawsuits. The vast majority of employment-related lawsuits are self-inflicted. They're the result of a leader doing the wrong thing or doing nothing when something should have been done. There's lots of liability out there for failure to act, failure to make a decision. Sometimes the breakdown is due to lack of knowledge. Sometimes it's due to lack of confidence. And lack of confidence can put us all right into lawsuit hell. It's interesting that when Newsweek put that cover together, they had 3 different occupations listed up there. When I'm putting this on for major universities, I hear, Mike, we're higher education, we're different. Yeah, there's another version of the course, just for leaders that aren't in law enforcement. When I'm putting this on in hospitals, okay, I hear, we're healthcare, we're different. Yeah, I got a version particularly for leaders in healthcare. When I'm putting this on at police departments, I hear the same thing. We're law enforcement, we're different. And they're all right outside of court. But once you get in court, no judge will take what any of us do, our occupation, into consideration. Expecting a different result based on what you do is a road to disaster. All right. Part of getting the laws work for you is why this course is named Reset the Clock. This is a process that prevents a plaintiff attorney from taking anything leaders did wrong or didn't do in the past and using it to attack their future employment-related decisions that they make. In the full 2-day course, there's lots of clock resets in this puppy, so that the entire department and all the leadership clocks, liability clocks, are reset to 0. Now, the first thing I want to discuss with you is how to make changes. Now, there's a procedure on page 1 of your handout for doing that. Look at the lead-off statement. When you choose to make changes and do them, Your employees are left with a choice to accept the change or quit, because the judges have said the mere fact that an employee didn't quit for all legal purposes means the employee accepted the change. As bold as that true statement is, we have to take something into consideration. The judges are very protective of the rights of employees because they share a belief that outside of the family, there's no relationship as close, as interdependent, or susceptible to abuse as this employer-employee relationship. The relationship between you and your employees is in 3 areas. What are your attendance, performance, and conduct standards? The procedure you have on this page is how to deal with changes in that area. Don't use this procedure to deal with any other types of changes. It's not required. But the judges have said, we expect you to meet these 3 standards, and then we'll protect you. Front load the change. Tell the employees it goes into effect next month, next week, tomorrow, but don't let any of your leaders write somebody up and tell them, oh yeah, we changed those rules. You can't manage by ambush. Just get it front loaded. As difficult and as demanding as every job in law enforcement is, it's still considered the nature of the job, reasonable working conditions. The 3rd standard, announce the change in a meeting where meetings are practical. Well, in police departments, meetings are practical. So let's go take a look at the procedure. First of all, because these are group standards, you have a group meeting. You tell your employees what the change is, why the commitment to it is important, and when it's going to go into effect, which could be any date other than yesterday. Deal with their questions, confirm the group knows what's expected. And then there's a statement, the 2nd bullet from the bottom. Ask for their commitment. Underline the word ask. The judges have taken the position because asking the question is totally within your control and is such a simple thing to do. If you don't ask the question, nothing happened that day. You have to ask to get it. Okay, so you ask a group of officers for their commitment. One of them gives you a thumbs up. Another one gives you, okay, boss. Some of them give you military-style salute. But you got one officer in your team who, typical of how they attend your meetings, just sits there. They look like they've been sucking lemons for about half an hour. No sign of commitment whatsoever. However, the next day that officer reports for duty. You got a sign of commitment from him now? Sure do, 100%, because he showed up for work. If you ask the team for their commitment, I can't guarantee you that somebody might not shout out something, like hell, not me, or something equally without tact. Worst thing a leader could do is take on that employee in a room full of their peers by saying something like, well, if you don't like change, you like being employed even less. That leader would have just toasted their leadership skills. The same thing would happen if the leader said nothing. Now we're concerned, don't you have any leadership skills? So if somebody interrupts your meeting, look at the quote. It's in your book, bold printed. You tell them, I'm available to discuss in private any personal concerns about the new standard. Coach your leaders if they're making changes at a level below you. If somebody comes to see you to explore an adjustment to the standard based on personal circumstances, do not adjust group standards based on personal circumstances. Here's what I can do to help you meet the standards, but I'm not changing the standards. Not knowing that first-level leaders have done this and caused their departments lots of lawsuits. There's no obligation to adjust group standards for personal circumstances. Here's what I can do to help you meet them, but I'm not changing them. All right, moving down the page. Tell the group that failure to comply will have consequences, and then you document what you did. Now on the next page, page 2, what you have here are some of the universally recognized rights you have because you're leaders. I want to call your attention to 3 on the list. The first 2, you get to decide who you want on your team. The second one, you get to set your standards. And then the last, you get to make changes. You and your leaders' use of any of these functions will be considered legitimate if it's in the best interest of your department. If any leader took something off this list and used it out of bias, friendship, prejudice, favoritism, it's going to get some negative attention. This is a list of our tools, not a list of weapons. Consistent with what I said earlier, this program, whether it's this 90-minute extract or the full 2-day program, focuses on what you can do, not on what you can't do. The next topic on this page, authority and responsibility go hand in hand. What would happen if a totally unbiased leader, somebody on your team, got input on an officer from another officer and used it that impacted the officer in a negative fashion? And this leader had no idea that the bias of the employee giving this information was there. Guess is in a check writing mode. I'm not saying don't trust your team members, but I'm telling you, here's the tactic. If you or any of your leaders get negative input on an officer, independently verify it before you make any decisions on the officer. The chief announced that the department was going to 12-hour shifts. An officer bid on one and was told no, and asked the chief, why am I not getting one? Chief said, I heard from somebody else that you talked down about the 12-hour shifts. The officer said, bring that person in and I'll call him a liar. I didn't say anything negative about the 12-hour shifts. The chief figured out what was going on and then offered this officer a solution. How would you like to work Monday through Thursday, 10-hour days, and have every Friday, Saturday, and Sunday off? Well, he solved the problem, okay? But he wouldn't have had to solve the problem if he'd independently verified it before he made the decision. What you have next are 3 things every one of your employees owes to you. They have to be on time, work their shift, and you might want to write this phrase down. We don't want any officer that has excessive unplanned absences. It doesn't matter whether they're paid or not. You have to be able to run a team. Excessive unplanned absences is grounds for a demotion or discharge. The third standard, work well with others. We're going to talk about how to handle individual severe personnel and attitude issues. On the bottom of this page, there are 3 key concepts of effective employee relations. Why is it important to be reasonable? Why is that more important than being logical? Manager at a restaurant up in Massachusetts couldn't figure out which of the waitresses was sneaking food out by the case. He lines them up against the wall in alphabetical order. Alice, I'm going to fire the thief today. You tell me that's you, there's the door. But if you tell me you're not the thief, because I know all you waitresses know what's going on around here, point down the line. Show me who the thief is. But if you tell me you're not a thief, and you don't know who the thief is, that means you're a thief or a liar and you're fired. And he had the same conversation with Betty and Carol and Diane and Gloria. We cannot use military theories of combat at work. There's no employee relations textbook recommending kill them all, let God sort them out. If you wanted to find something positive about his approach to the problem, you could say he was logical. Alpha order is about as logical as you can get. It's a great tool for solving lots of problems folks in law enforcement face, but it is not a great tool to solve every problem. It's a terrible tool when used to solve a relationship problem, whether on the job or at home. How far does logic get any of you in your relationship with your significant other? Isn't going to work any better on the job. You use logic to solve a relationship problem. In that context, here's the definition: a systematic method of coming to the wrong conclusion with confidence. Judges don't require us to be logical. They require us to be reasonable. In a given situation, one sergeant says, I'm going to handle it this way. Second sergeant says, I'm going to handle it this way. Third sergeant says, I'd handle it this way. 3 leaders, 3 different solutions to the same problem, and they're all fine because they're on the band of reasonableness. Terminating all your employees in alphabetical order didn't make the band. The second standard, make sure your leaders understand the importance of making all their decisions on attendance, performance, and conduct. And there's no way to attack it. How are employment-related decisions attacked anyway? They're attacked by claiming discrimination. Let me get to where I want to be. Under federal law, there are 9 protected statuses. If you take all the state laws added to the federal laws, now you have 36 different protected statuses. But if you pick up all the local laws, add them to the state and federal, don't count anything twice. Now we have 108 different protected statuses. But just reference to that list, what percentage of the U.S. workforce is in a protected status? Everyone, every employee is in at least 3 protected statuses. Well, let's test it. If you do not have a national origin, please stand up and identify your home planet. Anyone in this room not have a race? Whites are a protected status. Bitterly upset about discrimination by their leader, white employees went to their black supervisor, complaining, and he told them blacks have suffered for 200 years, now it's your turn. Put that organization right into check writing mode. There are women that hold women to higher standards they do men. There are Hispanics that hold Hispanics to higher standards they do everybody else. Does these decisions a reflection of protected status? No, it reflects character. That's it. And there isn't anybody that owns that. So we got 2. Anyone in this room not have a sex? The question's about status, not activity. Okay? What is the purpose of all of these statutes? To provide an employee with a potential legal remedy to attack decisions that weren't made on attendance, performance, or conduct. What plaintiff attorneys hope employees never figure out, if your leaders make all of their decisions on attendance, performance, or conduct, there's no potentially available theory to attack those decisions. I have personally fired lots of leaders working for me for discriminating. I have personally fired lots of leaders for not discriminating. There's illegal discrimination under the law. There's mandatory discrimination under employer policy. If you can't make decisions on attendance, performance, and conduct, you can't stay as a leader. The last theory on this page. Many employee relations lawsuits come into existence because the supervisors up the chain don't even recognize, I have to deal with this. The second thing, they react instead of respond. If one of your leaders, first level on up, has an emotional reaction, you may have a financial reaction as well, okay? Now the last one, any of your first level leaders turning something over to internal affairs or HR does not relieve that leader of shared responsibility for an effective solution. What all leaders have to understand, when there's an employee relations problem, you will be considered either part of the solution or part of the problem. Next page. Way too many times, first level leaders are writing people up for insubordination when the officer should have been written up for poor performance. And it's not understanding that you don't have insubordination unless you have evidence of defiance. An officer is given an order and shoots back, I'm not going to do it. Is that defiant? Is that insubordination? Yes, but we have to take something into consideration. Lots of times as human beings, words come out of our mouth, hit our own ears, and we realize, I made a mistake. You do not want to be accused, or have any of your leaders accused, of exploiting an isolated mistake. And there's something else to take into consideration. It takes your department a lot of time, effort, and cost to take a citizen and turn him into an effective police officer. And you don't want your department running into that negative thing, turnover, unless you got no choice. One of the things your leaders have got to understand is their role as a coach. Everyone knows, in this room knows, we know how to talk people into fights. We know how to talk them out. So tone of voice, choice of words is very important. This course has lots of scripts built in. The scripts are designed to build bonds instead of create barriers. So listen how it sounds. Follow along with me in the book if you want. Mike, you know you've got an obligation to follow my instructions. You know insubordination is serious misconduct. Now I'm going to repeat my instruction. If you don't comply, I'll have no choice but to treat your refusal as insubordination. Come on, please, don't put us there. If the officer says, okay, boss, I'll do it. That officer and every one of that officer's fellow officers is going to think, wow, our boss even protects us from ourselves. If, despite using this script, trying to build a bond, trying to solve this problem, the officer shoots back, I'm still not going to do it, well, you know who's made a decision. When you end up terminating this individual, what are the other officers going to think? Man, we really like Mike. We're going to miss Mike. Too bad Mike messed up. I'm not going to be mad at any of you because you didn't make the decision. You didn't, the employee self-selected out of the workforce. You gave him a chance. You did everything you could. Now, how are you going to help your leaders understand whether to write it up as a performance problem or insubordination? What can somebody defy? One of your orders, one of your instructions, one of your directives. One instance of that is grounds for demotion or discharge. But what about poor performance? If one of your leaders suggests to an officer you handle it this way and they handle it another way, write it up as a performance problem. If one of your leaders gives somebody an opinion, okay, and they have their own opinion. These are the last two bullet items. It's all written down there, bottom of this page. Okay, that's a performance problem. You may have some very reasonable expectation. An officer with X number of years should be able to handle this this way, and you're right. It's still a performance problem. You got enough performance problems, you got grounds for termination. Many of the departments that bring this program in-house, whether it's Ketchikan, Alaska, LAPD, White Plains, New York, Savannah, Georgia, or everywhere in Texas, this has been a big problem, okay? But this is the solution for it. Next page. If you're following along, you're with me on page 4. Tell your newly promoted leaders why you're a part of the squad. Everybody is friends. We're now putting you in charge of a group of your former peers. I want you to continue to be friendly with them, but these folks that work for you are no longer your friends. Some of them, when you coach them about performance problems, are going to cause your performance problems to your attention. You got to be prepared to deal with that. Tell them that your role as a leader begins today. Your team is neither going to see you as a motivator or a demotivator. If the only time your troops hear from you is when they've done something wrong, guess where your reputation is? This leave alone zap theory of leadership is a disaster. So the first thing is to coach them to recognize good performance. If your team is doing something right and they never get any feedback on it, you're running the risk they're just going to stop doing it because it doesn't give any intention. Tell your newly promoted leaders, there will be nothing wrong with you saying to your team, you folks are doing a great job, or an individual on it, you're doing a great job. But there is something wrong if that's all they hear. If all they hear is these general statements, they're going to conclude that the leader isn't paying attention, and that is a short trip for the employees to conclude, my leader doesn't care. And when employees think their leader doesn't care, it is fatal to the morale of the team and the productivity of the team. If the leader thought these were going to encourage good performance, it doesn't work because it's not specific. So one of the manuscripts in the book deals with that. You bring an officer in and say, Mike, you did something great this week, and you give him all the details. That's a private conversation. The officer joins their team. The other team members call something to his attention. Man, you're in a particularly good mood today. Well, you would be too. Let me tell you about the conversation I just had with our boss. Then the rest of the officers are going to conclude, our leader is paying attention. And since they all want your attention anyway, you've indirectly told them how to do it. Let me catch you doing something right. There's a definition of a performance problem in your book. It's also on the wall. Make sure your leaders understand this. Don't slap the label performance problem unless you've tied it into quality and quantity of work. If it's not that, there's another section in the book that deals with misconduct. We'll get to that later. But if it is quality and quantity of work, call it to the officer's attention immediately, because here's what happens if one of your leaders doesn't do that. The leader is upset about a particular officer's particular problem, performance problem, and has made a decision not to discuss it with the officer right now. The officer approaches the leader and asks him a question, and the leader answers it. But based on the leader's tone of voice, choice of words, body language, the officer is walking away thinking, my boss is upset with me, and I don't know why. There's 108 wrong guesses he could make. But the leader did document the problem. And because he's now documented 4 other occasions where the officer messed up, brings the officer in and says, okay, on this day you messed up this, and then you did the same thing on this date, and then this date, and then this date. Here's what the officer's thinking. Why didn't you tell me about this the first time I messed up? I'd have fixed it then. Because that leader showed up first with this list, the officer's thinking, my leader's more interested in building a list to get rid of me than to work with me to solve problems anybody could fix. So you got appropriate notice of it. Trust has just been destroyed. Trust is always a two-way street. While it existed, the officer saw the leader messed up. He gave his leader a heads up before the leader's leader could have a conversation with him. Can really destroy a team. How a leader starts the conversation with an officer can either put the officer in a defensive mindset or a cooperative mindset. Tell your leaders, don't bring somebody and say, you got yourself a problem. Guess where the mindset is. Here's another script out of the book. Mike, I'd like your help with something. Oh, what is it, boss? Well, I noticed a gap between what you did and what I expected, and you get into details. What can you tell me about it? I'll tell you why that question is so important. If you do have a performance problem, it's due to one of two things, deficiency in knowledge or deficiency in execution. If this leader asks this question, when the individual answers it, you're going to realize, is this a training issue? If it's deficiency in knowledge, is this something we have to periodically refresh people on? If it's a lateral transfer, is this something this individual said he had as a skill set, and now I'm finding out it's not here? If it's a deficiency in execution, the officers basically said they knew how to do it and didn't, so you explore why, and you ask for a commitment. If you ask, you get. Now, about the bottom 3 lines on this page. Why is it important for you to coach your leaders to keep records of poor performance? Here's what happens if they don't. Lone Star Gas, downtown Dallas, is defending itself from a discriminatory discharge case. There are evidence, 3 years of poor performance showing poor performance. Plaintiff attorney looked at the content of these documents and thought, I know how to win this case. Called to the judge and jury's attention. There is no discussion in these annual performance appraisals of any ongoing counseling. If these were really serious performance problems, don't you think they'd have talked about it more than once a year? Isn't the fact there's no record suspicious? Based on that, judge turned to the jury. Because Lone Star Gas does not have any testimony or documentation of ongoing counseling, you are free to disregard the performance appraisals, which is exactly what they did. If Lone Star Gas had spent 2 minutes with his leadership team, they wouldn't have been in court. What should they have told them? Told the leaders what their jobs actually are on an ongoing basis. Notice deficiencies in quality and quantity of work. And for everything you noticed, you notify the employee about what you noticed. And after that conversation, you keep a record. So it's notice, notify, note all year long. That's the second bullet from the bottom of the page. And then the last one, tell your leaders, for every criticism you put on a performance appraisal, string the dates from the notes. That process, this proves that if the performance appraisals are recap. If Lone Star Gas had told his leadership team, they wouldn't have been in court, let alone losing. All right, there's some other tactics on page 5. I want to, in the interest of time, get to the second one, erratic performance. I have to believe that your department wants to bring into it employees that can succeed on the job the way you define success. So let's say that you set that bar here, and you bring somebody on board, and what do you know? You were right. They are meeting expectations. You start paying attention to other things on your leadership plate, and you notice the new employee took a dive. Consistent with what we just covered, you call their attention to it right away, and we have a second period where the employee's up to speed. You think, okay, minor hiccup, now we're back on standard. What are you going to do if you see the second dive? You don't repeat the conversation you had the first time because it didn't work. So you tell the individual, twice now you've demonstrated you're capable of maintaining satisfactory performance, but you've taken a couple of dives. Because you've now proved twice that you're capable of operating at this level, the requirement isn't just that you pop up, it's that you stay up long term. Because you look in your book, the statement says, if you do not, we will have a decision to make. And if the employee questions you, what are you talking about, a decision to make? The script is in your book. I believe you will perform both satisfactorily and consistently, but I can't predict whether and to what extent you will. Accordingly, any decision today would be inappropriate. What you want to tell this individual in this second conversation, here's what I have to see from you. Immediate, sustained, good performance. That's the phrase. Now, this retention decision, which is what it is one of four options. Down the road a bit, since it's based on subsequent performance, you tell the officer, way to go, I knew you could do it, because they're now immediate, sustained, good performance. Or the second one, we're giving you a lateral transfer, it's a better fit for your skill set. Or another option. Options means they're not required. We're demoting you to this lesser position. We're not firing you, we're demoting you because we believe you can succeed in this position. Or the last one, I'm as disappointed as you this didn't work out. Why would you want to phrase it that way? We have to tell one of your sworn and non-sworn employees that their employment's being terminated. You are physically on the opposite side of the table from them. If you want to avoid lawsuits, be on the same side of the table with them emotionally. I'm as disappointed as you this didn't work out. Because you want to put something in the left-hand column. Here's what your leaders and you've got to make sure. It's a discharge with dignity. Okay? That's what you need. Discharge with dignity. Are there still handouts available on the back table? Yeah. Okay. Let's take a look at page 6. Very few individuals develop such severe personality and attitude issues that need to be fired for it, but it can happen. Somebody is a great team member, now it's clear it's not coming back. The officer appears to have experienced a post-hire personality shift. Maybe their coworkers informally diagnosed the officer suffering from OPD, obnoxious personality disorder. There's no reason to let any employee who meets your department's attendance and performance standards frustrate the leadership team, because you have the right to judge the acceptability as long as you don't discriminate. What's that mean? It means this. Make sure your leadership team has been coached to focus on what you can see and hear. And you're either going to be doing a consistent, how we've handled this issue in the past, or if somebody comes up with something you couldn't expect to see, something novel. So coach your leaders not to say to an employee, you've got a bad attitude, because that delivers a hidden message. I am your leader, I get to tell you what to think. We don't have that right. We can certainly tell anybody, I don't like what you did. I don't like what you said. Think what you like. You shouldn't have said it. Failure to get along with a supervisor is mentioned just below the middle of the page. Because she deserved it, she was taken out of the squad, put in charge of it. All of her peers are now her subordinates. All of them but one behaved towards her in a new role in a supportive fashion. This one employee didn't like this coworker. Now he's told they report to somebody he doesn't like. So what does he do? Continues to show up for work on time. Continues to push out the expected quality and quantity of work. But unlike the other officers, he never brings anything to the new sergeant's attention, which can cause any leader serious problems. Anytime she asks him a question, he responds with cryptic one-word answers, frustrating her. How do I phrase a question to this individual to get me a normal answer? Confidential coaching and counseling didn't work. That's discussed in the whole course. Formal corrective action didn't work. So when I have a brand new supervisor involved in a wrongful termination case, the employee walks into court. One army's got his great attendance records. One of his other army's got his great performance appraisals. The judge says, oh, that's irrelevant. You got terminated for misconduct. You know what his attorney didn't tell him? Those are separate tracks. You take out an officer for misconduct problems, it doesn't matter what's in those attendance files. It doesn't matter what's in those performance files. Employees are not allowed to combine them to attack a decision made on any one of them. You are, however. You might tell an officer, Mike, you got yourself some significant attendance problems, not enough to get you terminated. You've also got yourself some significant performance problems, not enough to get you terminated. You've also got yourself some significant conduct problems, not enough to get you terminated, but because all three exist, your employment is being terminated. Could be a three-way combo, two-way combo, or a single entree. It's what you order is what you get. The second from the last paragraph on this page. A bad personality is not recognized as a protected status because it's not tied to any one of them. Hope you appreciate the disclaimer. Now, terminating someone because of inappropriate conduct does not violate any law, including the disability laws. All right. Now let's take a look at a clock reset that I am not able to do in the course when I'm inside a police department, but we've already, in the full course, I've done a bunch of them, but this is one that only you can do. It could be that because these tools weren't known, I typically have a group of leaders thinking, our department, or I've been putting up with a whole lot of stuff I don't think I want to put up with anymore. So what do? You have a group meeting. You make sure the individual that's been causing you a problem is in attendance, but they haven't been messing up that day. Since we're in Philadelphia, I'll use them. You're telling the team, we're committed to maintaining a harmonious work environment. As part of our continuing efforts to initiate improvements when we need them, today I want to discuss with you certain misbehavior that I don't want to see again here in the Philadelphia Police Department. When any of us, and you give some examples, spread malicious rumors, provokes arguments, is rude, or as many chiefs have told me, when any of us continues to criticize decisions we made long ago, our harmonious work environment is disrupted. So from this point forward, each one of us must demonstrate a commitment to refrain from such misbehavior. I know I can count on your cooperation. However, if someone chooses to ignore this commitment, there's going to be consequences, irrespective of our past response. What's that phrase mean? In the past we did nothing, but don't use that phrase. Irrespective of our past response. From now on, such behavior will result in appropriate corrective action. At this point, everyone in the room but this one person will be thinking, what took you so long to address this? You got one individual thinking, this whole meeting was about me, I just know it. Hopefully they picked the day when they weren't disrupted, therefore they'll just sit there in silence and realize what they got away with in the department yesterday isn't going to exist anymore. What if despite that, the officer insists on attention? You hear from him in the room. Wants individual attention? Granted. Mike, is there something you want to share? I have no idea what any individual officer might say. I certainly know what's been very common for an individual to say. Free speech applies in this country. I can say anything I want. You can't do anything about it. Make sure the leader running this meeting does not take that officer on in a room full of their peers by saying something like, oh, well, this meeting's over. Everybody leave but you. Just use what's here. I'm sort of familiar with the First Amendment. I do know that thanks to it, none of us have to worry about getting taken into custody for what it might say on the job or anywhere else. It's also good for all of us that this law does not apply to our enforcement of policies designed to maintain a harmonious work environment. Half the room thinks that you're just back from a training program. Well, so what? You can now hold everybody accountable to the standards that you didn't know you could do the day before. It's a very powerful technique. Page 8. It could be that someone's loss of motivation. It could be their incoherent thought. Might be symptomatic of a mental disorder. Well, the thing to keep in mind is something I briefly mentioned earlier. Mental condition does not excuse misconduct. There are a number of things that, in the way of conduct, that you don't have to put up with. Just make sure your leadership team is coached this. Do not terminate anybody because of why they're being disruptive. Focus on what you're safe. Focus on why you're not safe. I don't want anybody in this room or any of your leaders, when an employee is being confronted about their misconduct, to get intimidated when the employee says, I've got a mental condition that makes me act this way and I am receiving treatment. If you terminate me, you'll be violating the American with Disability Act. As one untrained supervisor found out in court, he probably shouldn't have said to the employee, get your crazy ass out of my office. What he should have said is in the book. Let's consult with human resources. Perhaps we'll find a solution that will resolve this problem. I want everyone in the room to underline the word solution, because make sure your leaders know. Don't say reasonable accommodation, because when you're dealing with things like mental condition, you don't have to change standards or expectations. The solution may be stay on your medicine. If you're happy and you know it, don't change your dosage. Something, okay? Because your jobs involve public safety, you cannot allow anyone's behavior to be less acceptable just because they got a mental disability. Because if someone doesn't get what they expect of a police officer, it isn't just department liability. That's called negligent supervision. You have a big problem. You have to understand, I'm skipping a lot of meat in this 90-minute thing I've got here. Okay, let's go to page 9. Coach your leaders. And if any employee, sworn or non, comes to you with a complaint of unfair treatment or discrimination, here's what you do. You listen. Provide this officer focused attention. Avoid multitasking. Take notes. When the employee stops talking, read the notes back and ask this question. Did I get everything you said down right? All right. Then, depending upon how your department is set up, you're going to be contacting internal affairs or human resources. But here's why the word contact is bold printed. Do not send anybody to internal affairs. Send anybody to HR. Why? If someone is in front of this leader talking about discrimination, unfair treatment, that's an emotional issue. Your policies probably say go where you're most comfortable. But what if it says go in a particular direction? I'll get to that in a second. Why don't you send somebody? Because they're emotionally upset, they spilled their guts, they're emotionally spent, and they don't go anywhere for two reasons. They didn't choose to go there in the first place, and now they're emotionally destroyed. Should you take them to internal affairs? Take them to HR? No, because it discourages everybody else who doesn't want to be perp walked. All the prairie dogs are looking around. It discourages everybody else from filing complaints. So you make a phone call, and then whether it's IA or HR, you'll get together somewhere. I can't tell you how many conversations I had with an individual. It was at a restaurant. We kept it private. When judges have to choose between enforcing the law and enforcing your policy, which one are they going to pick? Here's an area where I find in reviewing policies to do this inside an organization, whether it's a police department or anybody else, policy problems. If it's this issue, you go here. This issue, you go here. Tell them, here's the judge's position. Notice to any leader at any level of leadership is notice to your whole department. So be careful that you coach your leaders how to handle this stuff. There's something else you want to tell your leaders. An employee may say to you, this is between you and me, Sarge. I don't want this going anywhere else. Well, it has to go somewhere else, because not reporting a potential policy violation is an actual policy violation by the leader. The next thing, anything that a leader says to an employee is on the record. There's no way any of these private one-on-one conversations are going to be considered off the record. Coach your leaders to understand that. These are tactics designed to keep you out of court, not to have you in court. Now, the bottom thing on this page. One of your captains, one of your lieutenants has been coaching an officer about a particular issue, and it didn't get resolved. So there was a second conversation, and it didn't get resolved. So then there's a third conversation and a fourth conversation. Eventually, the officer says to the leader, when are you going to stop harassing me about this? If that leader makes the mistake and says to the officer, this has nothing to do with your race, your sex, your age, by making that statement to the employee, the leader has put it in the employee's mind that that's in the leader's mind. It's a disaster. So here's the script. Bottom of page 9. You have to meet the standards that I've made clear to you. Want to notice the problem? I'm going to tell you about it. This provides you with an opportunity to correct it. This process will continue until the problem is resolved. Now, what I just said and what's in your book is not identical. That's because in the course I teach leaders it's okay to put things in your own words. This is all designed to build a bond between you and your officers. If you know their style, you know your style, run consistent with your style. It's okay to put things in your own words. Okay, page 10. There are individuals that will show up at a corrective action or progressive discipline meeting, and they say, I want to record this audio and or visual on my cell phone. Tell the individual, consistent with department policy, you can take notes, but there will be no recording of this conversation. Tell them again, look, if you insist on this, you could be charged with insubordination. If the individual says, well, I'm still going to record it. If you ask me to be in this meeting, I'm going to record it. Well, it's time for you and your staff to get together and make a decision. And it could be terminating for insubordination. Thanks to a case McDonald's fought at the federal level and won for all of us, any employee who defies a direct order not to use a recording device at a disciplinary meeting is fired for insubordination is McFinished. They're done, okay? All right. There's a preferred sequence of events here. About the middle of it, there's that phrase, can I have your commitment to correct this problem? That is a much superior phrase to I'm holding you accountable to doing this. That doesn't get you the commitment. But if you say, can I have your commitment, you get it. Now, if an individual says no, boy, is that individual outsmarted themselves. Predicting that you're not going to meet standards when asked to meet standards is grounds for termination of employment. It also is a disqualifier for unemployment compensation because it's considered serious misconduct to tell your boss, keep the money coming in, but I'm not going to do the work. Well, guess what? I'll get somebody in who will. If asked in a corrective action meeting, are you going to fire me? I'm confident you can turn the situation around. Isn't my confidence you justified? Again, if you get a negative answer, it's grounds for termination of employment. When you suspend an individual, the pressures on them on the suspension is off when they come back. Let's flip it. Tell the individual, I really hope you'll return to work after the end of this suspension, but I want you to understand something. Should you choose to report for duty and resume your duties, that is your commitment. That we're not going to see this problem again, and you're going to meet all my expectations on attendance, performance, and conduct going forward, so that you and I are clear between us. We're going to spend a few minutes going over those in detail. Then you do it. This officer comes back to work at the end of the suspension, walks in the door. Has the officer committed to not having the problem show up again and meeting all your expectations? See, now the pressure's on him when he goes back to work, and it's on long term. Whole better way of doing it. About the last bold printed item here. Last. It could be that some of your leaders are supervising officers and their work schedules are not identical. Sometimes they overlap, sometimes they're not. One of your leaders has been counseling an officer about a problem. The leader comes to work and gets a report that the officer messed up again, but the officer's not on duty. And this is not one of these days when they're overlap. So the leader writes it up, throws it on a mail slap, writes it up, throws it on a desk, and leaves. The officer comes to work, finds the document, and runs it all over the department. Look at this, my boss didn't even talk to me about this. Okay, stress everybody out. So send them a text, see me, call me, something. But kind of keep this in mind. Don't put documentation together. Make sure you coach your leaders until you talk to the employee, because this is what has to happen. Conversation before documentation. Coach your leaders. C comes before D in the dictionary, doesn't it? Don't switch it around. You got to verify the facts first. Okay. What else do you want to coach your leaders on? Documentation. One of the things that all leaders should be told, and you're not going to know unless you tell them, is when you write up a problem, address it to the employee. Don't write about the officer. Individuals hate it when they get these documents written to third parties. Mike, here's what you messed up. Here's what I need you to fix. You build a bond. You write it to them, not about them. And then, the specific details and precise facts as observed. I could never be a plaintiff attorney, but I've seen how this tactic works. A leader in a police department is on the stand, and the plaintiff attorney asks them, "Did you fire this officer for sleeping on the job? Is that right?" "Yes." "Did you personally observe this?" "Yes." "And you found him asleep on the job?" "Yes." Well, let me tell you why that's there. The first two questions answered by yes are what's to get the answer for the third question. It's a tactic. As soon as the leader says, "Yes, I found him asleep on the job," here's what the plaintiff attorney does. "Well, I see where your ears are. I see where your eyes are. Would you point out to the jury your finder?" And hoping the leader puts a rotten look on his face, says, that's his attitude towards his employees. It's a trick question. Okay? When plaintiff attorneys ask you trick questions in court, it's designed to make you look bad. When I ask trick questions in this course, it's designed to make the leaders look good on the job. So what I tell them is, don't worry about getting things wrong in this course. The more things you get wrong in the training program, the less problems you're going to have out on the job. The shakedown cruise and effective employee relations. So remember this tactic. Census. Support. Conclusions. Mike, you didn't respond when I did a radio check. I went down the hall and I heard snoring coming from behind the door. I opened it up and I saw the lights were out and you were lying down. You were motionless for 5 minutes. I saw that your eyes were shut. I saw that your mouth was open. There was a line of drool working its way towards your ear canal. Those are details, okay? Your defense is in the details. Bottom of this page, coach your leaders. Do not record anything about conduct, performance, or attendance, any of that stuff, unless you talk to the employee about it first. If it's important enough to document, it's important enough to have a conversation with. Secret records serve no valid legal purpose. I'm on page 12, attendance control. Judges handle attendance just like they do conduct and performance. They want to know supervisor by supervisor, did you set, communicate, enforce your standard? Can a city have an attendance standard? Of course. Can a police department have a much tighter attendance standard? Yes, it can. Can SWAT have an even tighter attendance attendance standard? Yes. It's not just attendance, it's a bunch of other things as well. So there's no universal or industry-based attendance standards. They just want to know supervisor by supervisor, did you set, communicate, enforce your standard? It's incredible how hard certain employees will work at not working. One employee knew, if I take another day off, I'm going to get fired, but he started looking through the city employee handbook and found the funeral leave policy. Went down to the local newspaper and faked his mother's obituary. Mom saw it in the paper. Went down to complain. The boss found out about it. He got fired. The chief of police wrote him up for disorderly conduct, and his brothers and sisters didn't want to talk to him anymore. I mean, pretty creative, but it sure didn't work. All right, FMLA is mentioned next in your book. Take a look at that. This is one of those statutes that allows an employee to decide who would you like to sue. Would you like to sue just your employer? Would you like to sue your employer and your immediate supervisor, collect 2 checks? Or would you like to sue just your leader? A state trooper went to his boss. I'm thinking about talking to the state HR folks to see if I can qualify for some FMLA leave. She said to him, why? You don't look sick to me. Already we're going in the wrong direction. I'm not sick. My wife's about to deliver our first kid. Based on my EMT background and a bunch of other things, I'm thinking about being certified as a newborn's primary caregiver. She said to the trooper, talking to state HR would be a total waste of your time. Your wife would have to be in a coma or dead for you to qualify for FMLA leave. Only a woman can take care of a newborn because only a woman could breastfeed. The award was $375,000, not against the department, against the supervisor personally, when the person in that courtroom thought that money was going to change hands. Why was the plaintiff attorney so happy? What's not known by you, because you haven't been in this mode, and I don't want you in this mode, is that once there's an award of individual liability like that, there's something that occurs. The leader is asked to show up around a conference table for post-trial settlement negotiations. Plaintiff attorney says, the judge's order says, you got to give us $375,000. The leader says, I don't have that kind of money. We expect you to say that. That's why we got the CPA here. As a condition of you avoiding a contempt of court citation, you've got to be thoroughly open and honest so we can find out what you actually can take, can afford. I don't know what actually changed hands because that didn't make the record. All right. It's incredible the number of employees that think FMLA stands for Friday, Monday Leave Act. Some supervisors think it stands for the Frustrate Management Leave Act. Well, here's what I'm going to tell you. Make sure you've told your leaders, anybody claims they want to explore FMLA leave, get out of the way. Don't do anything to discourage them from pursuing that. Once an individual has been approved from FMLA leave, don't threaten the employee about losing their job. One manager told an employee, I don't care what you've been certified for this leave. I can eliminate your job with a wave of a pen. And then he did so. $460,000 on that individual is what happened. All right, discharge meetings. 80% of all employment cases involve a discharge. You want to keep your department out of court. You don't want to draw any FaceTime with Judge Judy, the rest of them out there. Treat every termination as a potential lawsuit. Make sure first that protected status didn't figure into the discussion. The next thing you want to figure out is, I don't want our department charged with retaliation. So if an employee filed a charge of discrimination and then they end up getting terminated, can they claim it was retaliation for discrimination? Here's the key phrase. It depends on how much time between the resolution of the discrimination complaint and the discharge. If it's more than 6 months between them, the employee has to have some actual evidence other than the fact they filed the charge 6 months ago. If that's the 6-month rule, and there's the 1-year rule, don't bring it up. If a charge of discrimination was resolved, moved in one of 3 directions. It happened, here's the solution, it didn't happen, or we don't know what happened. And in more than a year, employee can't claim this thing, it's too old. All right, well, I'd like you to understand the whole course is very highly interactive. Everybody's in teams of 3. I'm challenging them with employee relations situations and asking them to apply the tools I gave them earlier in the course. So I can't do that in a 90-minute group this size. So I want you to just participate with me, and everyone in the room answer this question out loud. When your department has to terminate an officer, do you want to be fair? Do you want to be consistent? Do you want to be both? When your department has to choose, forced to choose between one and the other, which one you're going to pick? Pick fair. When there's an employment relations trial, we have 2 sets of attorneys on opposite sides of the courtroom arguing stuff. That jury is trying to figure out if your department was fair. If they think you were not fair, they will use any rationale to rule against you. 2 officers on the same day did the same misfraction. General Lawyer's Manual says that there is a range of things you can do from corrective action to discharge. One officer got terminated. One officer didn't. We weren't consistent. We were fair. Because what did we take into consideration? Look at the 3rd bullet. One had many years of service with the department. The other had very little. One had a great history of how they did their job. The other one had a terrible history of doing their job. The way to understand the relationship between fair and consistent is this. Being consistent only requires memory. Being fair requires thought. Big difference. When somebody is being told they're being terminated, you want to do it in a professional manner, which means you're going to tell this individual being terminated, we had a serious, unresolved problem with one of 3 things. Class, what are the 3 things? Attendance, performance, conduct. Make sure you coach your leaders. Don't ever tell somebody, we're letting you go, it's employment at will. That is a disaster. Employment at will was created by judges to use in the courtroom. It has no value in employee relations. If it's mentioned to an employee in a discharge meeting, you're going to court, okay? And you're going to win the lawsuit because the judges will use it there. But if you want to stay out of court, tie it to attendance, performance, and conduct. Your defense is in the details. Many of the not as many as used to be, but some departments have unionized police officers. I happen to have expertise in both labor and employment law, but I'll say that for another day. When an individual is told their employment is being terminated, the employer may claim this decision stinks, it's discriminatory, unfair. What you want to train your leaders to understand is to say this. I understand that's your position, but we do not agree with you. Underline the word we, because discharge decisions have to be team decisions. The first time I put a group of chiefs of police through this program in Texas, they said, Mike, you're telling discharge decisions have to be team decisions, and by policy, as the chief, I have to make all the discharge decisions. And I said, Chief, you have to understand this about policy. You can always be better than your policy. You just can't be worse. But if the policy says you have to make the decision, and you make the decision in a vacuum all by yourself, you have individual liability. Because one of the things that's clear about discharge cases where punitive damages were leveled, they had one thing in common. They were individually made decisions. There are no cases at the federal or state level where a team made a decision, is something called stupid or mean, it turned this liability clock on. So here's what you do. You got internal affairs, going to run the investigation, reasonable duration and scope, give you the facts. You've got people that report to you as leaders. The immediate supervisor over this officer, their boss, whoever you got. Pull them all together and working your way up in rank, see what they get. And then you're in a position to say, I concur. Or you're in a position to say, I need to talk to our legal advisor. It's still going to be a team decision, and just by going through the process, you've avoided individual liability. You can always be better than your policy. You just can't be worse. I used to spend a lot of time drafting general orders manuals, but there's a group out there. I haven't been out on the floor, but if Lexipol is here. They do a great job of writing general orders manuals and policies. Now, why do you want to make that statement? I understand your position, but we don't agree with you. Because if everybody there says nothing, plaintiff attorneys will convince people, silence is considered agreement, let's file a lawsuit. And it's not true in court, but our goal is to stay out of court. Every time you save an employee $10,000 in legal fees, guess what you save your department? Try moving the decimal point. What else do you want to coach your leaders in a termination meeting? Don't say, I am sorry it's come to this. Don't apologize at all. All statements of apologies are held to reflect guilt and certainty of wrongdoing. Don't do it. If anybody who's being terminated says, what about this officer? What about this officer? There's your script. It would be inappropriate for to discuss the situation of any other employee. I'm on page 13. You have grounds to terminate an officer. And you tell that to the officer and say, if you resign, we'll let you. And the officer says, I resign. 100% of the time, that officer can go to a plaintiff attorney and sue the department for discharge. Whether a resignation will be treated as a resignation or discharge depends on one fact: who brought it up first. You bring it up first, employee accepts it, that's a discharge. Now, in everywhere else but law enforcement, that's a big problem. It may not be a problem for you based on this. If this individual wants to continue their job in law enforcement, it's better that it's on the record they resign. So if that is the situation, when you bring it up, they're not going to sue your department. But if it's an individual that's given up on law enforcement, well, then you have the same risk everybody else has. Now, it's quite possible if your organization has HR that they can coach an employee what their options are going into the discharge meeting. So if that's happened in a discharge meeting, employee says, will you let me resign? And one of the leaders says this: whether to resign or not is up to you. We have no control over decisions that are yours alone to make. If that officer says, I resign, well, now we have no problem at all. That's a resignation. Some other issues. Are you going to fight me on unemployment comp? Second bullet on page 13. If you apply, I expect you to tell the truth. Count on me to do the same. The agency makes its own decisions. If an employee says, am I eligible for rehire? Hell no, if I have anything to say about it, is the wrong answer. Everyone has a right to file an application. Your prior service will be a factor in whether you'll be made a job offer. If an officer shows up unexpectedly, resigns, and tells you they're unhappy about something at work, you say this: complaints can be resolved while you're working here. There's no intention to force you to resign. If the officer says, I'm resigning anyway, if your leader has a record, they made that statement, you've made it impossible for a plaintiff attorney to claim the resignation should be treated as a discharge. Reference checks. Tell your leaders to be very careful when individuals are trying to get a job somewhere else or they've been fired. They know not to call the department. They're going to call leaders on cell phones. Even if it's on your cell phone, our policy refers your call to, and it's either IA or HR, depending upon your organization is set up. Because there is an organization out there on the internet, badreference.com, that tells people for about $85, give us your name of your supervisor's name and personal phone number. We'll make a relentless effort to catch them on the phone, record the conversation, send you the transcript. What was recorded on one transcript, any special problems we should be aware of? Supervisor was answered. Well, that's hard to say. I don't know what my liabilities are in this situation. He was terminated because of drugs. Prescription drugs? No. Cost the supervisor a $250,000 settlement. That means the money did change hands. All right, there's a clock reset to make sure you don't have to worry about that in the full program. Internal communication. When one of your officers has been fired, make sure everyone in the leadership team knows you can't be talking to brother officers about why you terminated someone. You can only say, Mike no longer works for us. Here's how we're going to temporarily divide up the work until we find a long-term solution. Because if they give the details and the discharge officer finds out about it, we'll sue that leader for invasion of privacy, and truth is not a defense. Page 14. It could be that one of your officers is got a disability that has workplace impact, potential workplace impact. You can only indirectly raise the possibility of a reasonable accommodation. You can't say, I know you got this disability, let's talk it through. You can't do it. No leaders can. The law is very clear. You can point out the deficiencies in quality work. Is there any way we can help you improve your performance? If the individual doesn't raise for discussion their disability or limitations from it, we have no duty to accommodate. You call attention to the department's resources and tell the officer, improve your work and face the consequences. The bottom half of this page. Employees that have personal hygiene problems are often in complete denial about their negative impact on your work environment. If anyone comes to you or any of your leaders expresses reluctance to work around somebody due to this issue, you can't farm this out to internal affairs. You can't farm this out to HR. You're the leader. Whoever's the leader's got this has got to do it. You have a conversation with the employee at the end of the shift to minimize embarrassment. You do it in private at the end of the day because they can't fix it on the job. And there's some scripted language here. You give them some general rules, and then you identify the specific problem. I have noticed that your bad breath or your body odor is having a negative impact on our work environment. I understand it's difficult to hear, but I have a duty to you and your coworker to discuss it with you. You have a duty to resolve it. The failure to do so could result in corrective action. Is there any way we can help you resolve this? Well, if it says due to a medical condition, you talk to HR. But why does it say, the first bullet near the bottom, I have noticed? Because leaders make a mistake. Your coworkers have told me you stink. No, you have to keep it to yourself, okay? I have noticed it. Don't push it off on anybody else, okay? All right, there's a slide I want to put up now. What is effective employee relations? It means we're not in court. The problem I have with compliance-based training programs is this. They train people what the law is and stop. Well, there's a problem with that. All leaders' decisions will be challenged by reference to some legal standard. I know you don't want that because you've got policy manuals and city handbooks. What do? They provide more fairness than is legally required. But even that's not good enough because it doesn't really address day-to-day things. What happens is a problem happens, and all of a sudden the general orders manual gets a page bigger. What really is going to do, keep you out, is giving your employees a square deal. See that your entire leadership team gives your sworn and non-sworn employees a square deal. Square's got 4 corners. Be reasonable, be consistent, use common sense, common decency. If your leadership team is doing that, they're being fair. So being fair, good judgment, same thing. Okay? So consistency is a part of fair, not identical. The editor for the Dallas Morning News, in preparation for an article, asked me a question. I've been talking to senior reps of big employers in the Dallas-Fort Worth area and asking them this: why do we keep having fresh employment-related lawsuits? And the answer I get is, oh, we got the best of intentions to comply with this stuff. And I said, they're telling you got the best of intentions to comply with this stuff? We may judge ourselves by our intentions. What's everybody else judge us by? If you really want to stay out of court, it's not rocket science. But there are some mandatory requirements. What are they? 1, you have excellent written policies and procedures. I already mentioned my great recommendation, talk to the Lexapol people. They got it. As soon as I realized what they had done, I stopped doing general orders myself, okay? And then what else do you have to do? You have to have training programs, two types, for your leaders and for your employees. Now, when I did Dallas PD, as I do all the other PDs across the country, there is a section for them. I give the departments the handouts, I give them the PowerPoints. It's called Towards a Harmonious Work Environment, and there's a lot of scripts built into it. And then once the leaders, once the employees have been trained, then you have to have active enforcement. Your entire leadership team has to actively enforce this stuff. If there's a breakdown in any of that, you got good intentions and legal exposure. If you don't have it, breakdown, then you got legal protection. Now, what have the judges have said about excellent policies? Step in the right direction. But they've also said this: failure to train voids the protection from punitive damages. They've made it clear time and time again. The EEOC goes into court, finds out the issue is lack of training. The EEOC makes a motion, the judge grants it. The EEOC is going to maintain jurisdiction over your department for the next 5 years. Every 6 months, they're going to require some reports and inspection. And my court order, you have to put your leadership team through a training program. Well, if you put them through compliance-based training programs, you guarantee you can win lawsuits. That teaches them what not to do. If you teach them what to do, you don't have the lawsuits. I don't want any chief in this room ever finding out that you could have avoided something, okay? Now, you don't want to ever hear that. You should all be very proud of the fact of what you do for your communities. Lots of people like to say thanks. I told you at the beginning of this, I wanted to show you thanks by putting you through this piece of this program. My goals for this 90 minutes we spent together, same thing for the whole course: to increase your practical knowledge and competence in handling sensitive employee relations issues. Practical knowledge, 2 words. Could that be distilled down to 1? Wisdom. There's a big difference between knowledge and wisdom. Knowledge is knowing a tomato is a fruit. Wisdom is not putting it in a fruit salad. All right. I have a relationship with a number of organizations, but I'm housed at ILEA. I have been since it opened. That's the Institute for Law Enforcement Administration. Today I'm going to be hanging out at our booth downstairs. I haven't been to see it. I'd be happy to talk to you about how I might be able to help you, but one of the things I want to call your attention to is on this page. Check out that solutions finder. That is what all leaders at all levels have to know how to handle these sensitive employee relations situations. The reason there's reference to the pages is this: I tell the leaders, you don't have to memorize this stuff. You don't have to memorize where it is in the book. You run into one of these sensitive issues, you go to the solutions finder, you look it up, and you read it out of the book. And an officer says, hey, you just read that out of a book. You're going to say, yes, I did. I like to get things done right. And I'm going to add it to my notes, you noticed I read it out of the book. Don't be afraid of reading it out of the book. These are tools. If you want to see what this book looks like, I'll have it with me downstairs. I can also show you the Dallas PD Toward the Harmonious Work Environment. Every police department is different on these things, and so I have to make them customized it. What else? I have put the law enforcement version of this program on 142 times, whether it's, and I named all the different states I've done it in. But there are 2,040 chiefs have been through the full program, in addition to the leaders below them, which would be another 5,800 other leaders that have been through this program. And that's pretty much because I work with a lot of different law enforcement associations. a couple years ago, I got added to the FBI's preferred speaker list. If you have organizations that would like associate statewide organizations, I'd love to work with yours as well. My direct phone number is on the front of this book. If you come to see me, I'll give you my cell phone number as well. But back to the Solutions Finder. I have left the last 6 minutes in this program open. If you wish to have me discuss any one of these things because you've got a current need, just say the question loud enough, and I will look it up and give you the answer if I don't have it memorized. So take a look at that Solutions Finder, and if there's something off that, any questions you want to ask me, I'd be happy to entertain it. If not, I look forward to meeting many of you. It's incredible, since 2003, how many friends in law enforcement I've been able to maintain good relationships with. Most of my LinkedIn folks are now chiefs of police, but that's great. What are your questions you've got? We got 5 minutes left. What can I help you with? What would you like to know? Yes, sir.
Just a little bit off the beaten path on the list there. You mentioned earlier in the program about not allowing employees to report like disciplinary hearings or
Yep.
do you advise that management does make copies available, or
It depends on the culture of the police department. If your culture is, when we do these disciplinary meetings, we're recording it, might as well let the employee record it. If your purpose is, your general rule is no, don't do it, because the difference between professional leaders and non-professional leaders is you got records. And when you record things, it changes the caliber of the conversation, the content, it changes everything. Just take notes, and you're fine. Does that answer it?
yes?
Okay. Well, really glad to get to know you. I know some of the room have already been through this program, and thanks for saying hello to me before I got started. If I can help you down the road. LEMIT, the Law Enforcement Management Institute of Texas, has already got me scheduled to do an open session in Huntsville, Texas, January 9th and 10th. If you want information on that, contact LEMIT directly or contact me. I'll get you in contact with LEMIT. If you want to talk about bring me into your department, see me during today, because I've already got work booked in law enforcement through next August, okay? People book me in advance to make sure I can meet their dates, but doesn't mean I can't book between now and then. It's just, I stay busy. You serve and protect your communities, I serve and protect you and your command staff. Thank you for being here.